Welcome to U.S. Immigration TV. In this video, I will discuss what happens if a K-1 fiancé divorces their U.S. citizen petitioner before getting a green card. Well, what can be done? Is there hope? Well, make sure to watch this video until the end for the answers. And of course, like, share, and subscribe to this channel. Well, by way of background, the K-1 or fiancé visa is Cupid's visa. It's the visa of love. It's designed for U.S. citizens to petition the love of their lives for a non-immigrant or K-1 visa so they can come to the U.S., marry within 90 days, apply for adjustment of status or a green card, and thereafter live happily ever after. If they don't marry within the 90 days, or let's say they don't marry at all, the K-1 fiancé is required to go back to their home country. They can't come in on a K-1 and remain here if they don't marry the citizen. Well, the K-1 fiancé visa also has very strict limitations and requirements. If a person enters on a K-1 visa, the one and only way they can get a green card in the U.S. is through that U.S. citizen who originally filed the K-1 petition. If the marriage does not work out, they cannot find a different way to get a green card in the U.S., such as divorcing and marrying a different U.S. citizen, being petitioned by an employer, or a U.S. citizen child over 21 years of age. In such cases, they would be required to depart the U.S. and apply for their immigrant visa abroad, typically after obtaining a provisional waiver. Another strict limitation or requirement for K-1 visa holders is that the petitioner must submit an affidavit of support or I-864, or the case will be denied on public charge grounds. This is the case even if someone else is willing to step in and submit an affidavit of support, let's say as a substitute sponsor, let's say a relative, in case the petitioner does not want to submit that affidavit of support. No, they must submit the affidavit of support. The only exception to the requirement of having an affidavit of support by the petitioner are abuse and death. In other words, the K-1 visa holder was the victim of domestic violence, or the petitioner died and they are now a widow. But is there hope for a K-1 fiancé who enters the U.S., marries the U.S. citizen petitioner, files for adjustment of status, but then the marriage fizzles out and the U.S. citizen files for divorce? Well, the answer is yes. There could be hope if certain requirements are met. Now, courts have already held that a K-1 visa holder could still adjust status even if the couple divorces, as long as, and this is important, the petitioner has not withdrawn the affidavit of support or I-864. Therefore, keeping that affidavit of support in place is critical in connection with a K-1 fiancé's ability to adjust status in the U.S. So if you entered the U.S. on a K-1 visa and the U.S. citizen is divorcing you, well, you may want to consider hiring a family law or divorce lawyer to represent you in the divorce proceedings and protect or keep in place the affidavit of support so as to enable you to still be able to adjust status in the U.S. If you just blindly agree to the divorce without making provisions for keeping your affidavit of support in place, then you may lose all hope or chance of getting a green card in the U.S. In fact, in one case, the Board of Immigration Appeals, or BIA, noted that there could be several options available if the couple is divorcing. One option is that the petitioner could agree to leave his affidavit of support in place while the K-1 beneficiary's adjustment application is pending, an amicable divorce. Another option is the divorcing K-1 applicant could agree as a negotiated term in the divorce proceedings not to sue the petitioner for breach of his contractual obligations under the I-864, which actually survives divorce. In other words, one of the terms of the divorce could be to require the U.S. citizen not to withdraw the affidavit of support, as it could effectively be an alimony agreement or contract. Now, if you entered the U.S. on a K-1 visa and your marriage is not working out you may want to consult with an immigration attorney who could possibly work with a family law or divorce attorney to protect the affidavit of support and enable you to adjust status in the U.S. despite a divorce. Otherwise, if you don't protect that affidavit of support or it's withdrawn, and you find a different way to be petitioned, such as a new U.S. citizen spouse, a 21-year-old citizen child or employer, you would have to then obtain a provisional waiver, leave the U.S., and apply for your immigrant visa abroad. However, as you can see, there is hope for a K-1 visa holder to still obtain a green card in the U.S. despite a divorce. Now, I hope you have found this video helpful and informative, or maybe you know somebody in this situation and you want to share this video with them. And of course, make sure yourself to like, share, and subscribe to this channel, because I'm always posting videos what I think will be helpful to you in your immigration situation. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.